And now we move on back to the Lex Societatis layer of legal arbitrage and corporate finance. Speaking to us is Martin Gelter. Martin Gelter teaches at Fordham Law School in New York, but he's no stranger to this town either because he's been raised both personally and academically in here. And so you're not really a guest, you're at home, but we're thankful for you coming anyway. Thank you.
Thank you, Chris. Thank you for having me. I mean, it's always wonderful to be in Vienna for academic reasons and not just for personal ones. I think there's been a little bit of confusion about the paper title of my presentation, in part because I have this project that I've been working on since 2017, which I'm kind of fed up with, but it's out, and I hope this is the last time I talk about it. On the other hand, I thought, given the developments in the US that we've touched upon in a couple of presentations in the morning especially, I thought I should talk a little bit about that too before I get to my own research. I think that makes sense. So I'll start with a sort of general overview and then move on to my own to what I've done, which I think is not that interesting theoretically, although you might disagree. So we are familiar with regulatory arbitrage, right? Which is something that we think a lot about in federal systems, right? If we have different layers of legislation or different competing jurisdictions, right? Who should make law? Should it be the federal government? Should it be the states? Should we have harmonization in Europe, or should we leave it to the member states? It's always a difficult question. And then once we have competition, we ask who are the dominant players. So these are all topics that we have touched upon deeply today. And in the corporate law context, I guess it is the question of whether Lex Societatis should apply. Should it be the firm where should it be the country that where most of the business is done that also governs its corporate law, or should firms be able to choose, right? So we know that, right? This is the US with a little circle around Delaware, which is I suppose an insignificant state in terms of its population size, but it is, of course, a giant in corporate law. And as you know, this is because of United States has, you could call it, free choice of the place of incorporation. We have the internal affairs rule, which says that the internal affairs of the corporation are governed by the state where it is registered, where it is incorporated. So not where its real seat is located or anything like that, right? And as I'm sure people are aware of, Delaware dominates the market among publicly traded firms, right? And this is where we've discussed. Luca gave us a little bit of the intellectual history this morning about the race to the top, race to the bottom. There are countless papers about it. The race to nowhere in particular, lots of great titles. And there's also the question of whether what the interaction with federal securities law is, right? In publicly traded corporations in particular, whether a federal securities law pulls Delaware in a certain direction, because if it went out of control, then maybe we would see some development in we might see more federalization, and Delaware doesn't want that, right? So what I'm talking about, and what I'll be getting back to when I'll talk about Europe, is privately held corporations in particular, and LLCs or their equivalents. And the conventional story, I guess, in the US there is that usually it is a choice between the home state and Delaware, right? If you set up a business. I mean, there's one thing to be said. If you set up a business in one state, you also have to for certain purposes, if you are actually registered in another state, you also have to additionally register that company in the state where you actually do business. Otherwise, in some states, you might get fines. In most, it just hinders jurisdictional enforcement. But basically, lawyers would advise you to incorporate either in your home state or in Delaware. And the story that some of the empirical research has told is that for both privately held corporations and LLCs, limited liability companies, the freedom of contract plays a considerable role. What you can do in the states, what does it look like in terms of director exculpation? Are they subject to liability risks? What about piercing the corporate veil? So in privately held corporations, I think the idea is usually that these factors play a role, but this is not what we usually think about among publicly traded corporations, right? When we talk about publicly traded corporations, where we have this big debate about race to the top, race to the bottom, it is about the balance between managers and shareholders, right? Agency cost and such like. And of course, private ordering does play a role in that too, but not but in a different way. So before I move to Europe, I want to talk a little bit about what happens in Delaware in the last couple of months, because I think this is quite exciting, and Luca and Alperen and Noreen have talked about it, right? You probably heard about it, even the those who are not so involved into American business issues. The Tornetta versus Musk case in 2024, where which goes back to an executive compensation award that Elon Musk received was given I think in 2017 or so, when I started my minimum capital research, actually, and which took the form of stock options, which resulted in, ultimately, because the Tesla stock had actually gone up, in him becoming potentially $56 billion richer. And the Delaware Chancery Court Chancellor McCormick struck down this award after a lawsuit, and repeatedly, right? Even after he tried to get shareholders to ratify, right? And then there was also the Match.com case that some of you, I'm sure many of you have heard about as well, is which basically says that the so-called MFW framework, which is a doctrinal framework that applies to self-dealing transactions, that was developed in the context of freeze-outs going private transactions, also applies to other self-dealing transactions with controlling shareholders. So this basically means you need both a special committee and a majority of minority approval to get the benefit of the business judgment rule. Otherwise, the entire fairness test applies. So for those who are not so familiar with how U.S. law, Delaware fiduciary duty doctrine sort of functions, is usually you start with you identify a transaction as a conflicted transaction, right? Then the entire fairness test would apply instead of the business judgment rule. And then there's the question, how do you get out of this? And in the case of controlling shareholders, the Delaware courts had come to the conclusion you need a special committee. So the transaction has to be conditioned on the approval of the special committee that has to meet certain requirements. They have to have bargaining powers. They might get their own counsel. They will produce a big report. And the transaction will only happen if this committee approves. And then also a majority of the minority shareholders approves it, right? So this is seems pretty great. In the case of Elon Musk's executive compensation, there was board approval. I mean, the Delaware courts generally had not been so stingy about executive compensation historically. And the so in that case, the board that approved his transaction, who was on that board, right? His brother, Peter Thiel, his friend, but a lot of people that were pretty friendly with him. So the whole process was tainted in the view of the court. So there is a good argument to be made that this was not what you want to see, right? And then Elon Musk was not able to show that the transaction was entirely fair. In how Delaware courts would usually interpret it. So that's how this came down, and this resulted in a big debate. And then you get a reaction. You get not just regulatory arbitrage, but regulatory competition, maybe, where some firms, not too many actually, I think, but a few firms go to or threaten to go to incorporate to Texas, to Nevada, and then the Delaware passes SB 21, which changes a few things. And I think there are a couple of things in it. I think to me, the most important aspects are that under if a transaction is not a going private transaction under Delaware SB1, you need either committee approval or board approval. And there's also a more, I guess, controller-friendly definition of what what constitutes an independent director for these purposes. And then it limits the definition of who is a controlling shareholder. And if the stockholder in question does not have the voting power or contractual control rights to appoint, I think, a majority of directors, then that person would have to have at least 1/3 of the stock, which Elon Musk is a so-called minority controller, right? Which literature now says is particularly dangerous. Somebody, I think he holds like around 20% or so of the stock, but he has multiple voting shares, and through that he clearly he sort of practically is a controlling shareholder, but not under that definition, right? So, and I think that's what's kind of interesting, because to me, as a continental European, it seems like this is kind of like what Austrian lawyers like, right? We want a bright line rule, right, that we can plan around, and then this will never apply again, right? I think over my time here, I've seen this kind of thing a couple of times, right? And this kind of thing was pushed for by especially Silicon Valley firms, especially. So I've been to a couple of discussions where this kind of came up, and there wasn't really a lot of resistance among in the Delaware legislature. But law professors are all up in arms, and I think there's almost nobody who's in favor of it, or very few people, right? So that's kind of interesting, right? And then I think regulatory competition is going on. Texas is picking it up. So there is a new law in Texas. So I'm by no means an expert on Texas corporate law, but so they've moved toward creating, because there were a number of questions about Texas, how their law develops or should develop. And I think there were, so one thing they have now is a business court, which was always a question, because Delaware, one of its advantages has always been the business expertise of the Chancery Court, which does not have a jury trial also. And so they established a business court. They it allows this new amendment allows for a waiver of jury trial for in the corporate organizational documents, in the government governing documents. So I assume the articles or bylaws, which would recreate that advantage in Texas. It's limits fiduciary duties, right? The presumption of directors in office there's a presumption of directors in office acting in good faith, unless fraud, intentional misconduct, knowing violations of law, or acts ultra vires are shown. And then, and Delaware hasn't gone that far yet, right? A publicly traded firm may require that a percentage limit that is necessary to bring a derivative suit, and I think which can go up to 3%. And we know that from many European countries, right? If you have such a percentage limit, then the result is there are no derivative suits, right? And I think Austria would be a good case for that, right? So that is kind of interesting, and you see that the regulatory competition is quite alive. So before I go to my own European research, I'll just say I think it is quite interesting that a lot of this is now coming up in the context of controlling shareholders, right, with Elon Musk and other people, which is actually something that a couple of people who are writing about regulatory competition coming to Europe 20 years ago, we were all thinking, with controlling shareholders, maybe regulatory competition is actually more dangerous than with if it's between shareholders and managers. And I think it relates also to some of the literature that Luca was citing from Lucian Bebchuk and others, because a controlling shareholder has usually the initiative, and I think the danger of regulatory competition going into the bottom direction, maybe not below the bottom, but somewhere to the bottom, like Chris said this morning, this is very much present. So that is what I wanted to say about the US, and I'll get back to my European research, which I have to say I'm a little bit bored with by now, but I will show you what we did. So this is the EU, right, or it used to be the EU with the UK, and this is stuff, all that. This is just here from a previous presentation. We've got EU directives, we've got public limited companies, private limited companies, minimum capital, legal capital requirements, super controversial, right? So that's not an issue in the US, Europe always had, for a long time, had this debate about incorporation theory versus real seed theory. So could you incorporate in a country outside of your own turf, or could you not, right? So I think many of you will remember all that. Some of the younger people might not, right? All this debate that started with Centros. But I mean, today you can incorporate in other states of member states of the European Union, right? And in the 2000s, because of these famous cases, sort of a movement sprang up to move to the United Kingdom or to set up startups or new firms, usually with very limited business purposes in the UK. And often they were aided by specialized agents. And so what motivated this paper and other papers that studied this kind of topic was I guess the question of defensive regulatory competition. So a term that has been used a couple of times already today. Maybe you want to make your own law less attractive to prevent the flight to other member states. Maybe you want to eliminate your minimum capital, or create new legal forms that can be formed with less bureaucracy involved, right? And the examples, poster child examples, it's been a while. I think the German MOMIC in 2008 was an example that sort of led the way to that debate. I think the Belgian example is also quite interesting, but since then it's kind of been superseded by a private limited company law that is very US inspired, without a real capital system anymore. So many countries changed this. And the question is whether these reforms had an impact. And there's been some controversy in the literature, I guess. So early in the debate, Bechtmeier and Wagner, I think, studied the impact of the centrist case very comprehensively. The subsequent papers that looked at this were a bit more limited in that they looked at a limited number of countries only, as in the case of Brown et al. Or Ringe, all great papers. Gerner-Breuerle et al., a great paper, but they looked at data up from 1 year, basically, and they're mainly interested in private international law rules. So what I thought is, let's look at the UK, redo some of what these papers have done, but more comprehensively, look at companies going to the UK, newly founded companies, and let's look at minimum capital requirements, create a big timeline for each country, how it developed, and then let's see statistically whether there is a connection in the number of firms. So which turned out to take a lot of time because it is kind of econometrically, so I hope there are not too many economists here because I will get in trouble with econometrics, but it takes a lot of time to do that kind of stuff. And so the data came from the Bureau Van Dyck Orbis database. So I updated this 2 years ago to add more years. And we searched for all private limited companies that were set up in the UK. So while it was still an EU member, and where at least one director is a national or a resident of the 31 countries, including active and inactive firms. You'll see many of the firms are no longer inactive, or most of them are no longer active. And then count the firms, basically. And the statistics, they look at 31 countries, so all of the EU, European Economic Area, Switzerland also, because it's easy to research, and minus the UK, because that is the target country. 26 years, so it's kind of a nice panel.